Hello, welcome to Vidu Law Niti. Today's topic is about Article 13, law inconsistent with or derogation of the fundamental rights, validity of pre constitutional and post constitutional laws. Now, let us note the introduction of Article 13. It lays down the rules of interpretation in regard to the law inconsistent of the fundamental rights. The law passed by the Parliament cannot be violated in fundamental rights. If any such law is inconsistent with or in the derogation of any fundamental rights, and it shall be termed as unconstitutional and will thus be null and void. This amazing law brought us in our constitution under Article 13. This article provides doctrine of judicial review. Although the word judicial is not mentioned in the constitution, Article 13 clearly uses this doctrine for checking the validity of the law. The significance of judicial review to ensure that the democracy is inclusive and there is accountability of everyone who is wield or exercise the public power. The principle of judicial review becomes an essential feature of Indian Constitution. The power of judicial review is incorporated in Article 226 and 227 of the Constitution as the High Courts are concerned and in regard to Supreme Courts, Article 32 and 136 of the Constitution. The judicial review is a power to go pronounce upon the constitutionality of legislative acts which falls within their normal jurisdiction to enforce and the power to refuse to enforce such as they find to be unconstitutional and hence void. Now let us know about the pre-constitution, that is Article 13 Clause 1. All laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall to be extent of such inconsistency be void. This means in this article, whichever the law is inconsistent or do not value it, it is a void. Whichever the law is in the consistent, that is will be valid. Post Constitution, Article 13 Clause 2. The state shall not make any law which takes away or abrogates the rights conferred by this part, and any law made in the contravention of this clause shall to the extent of the contravention be void. This means after the constitution came into force, the state is prohibited to make any law inconsistent with the fundamental rights against. Article 13 Clause 3a. Law includes any ordinance, order, bylaw, rules, regulation, notification, customs or usage having in the territory of India the force of law. B. Law in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be there in operation either at all or in particular areas. This means all the laws that can be affected the legal rights of a citizen. There are two types of law, that is permanent law enacted by the parliament or a state legislation. Temporary law, it like a ordinances issued by the president or a state governor. Next one is Article 13 Clause 4. Nothing in this article shall apply to any amendment of this constitution made under Article 368. Means this clause simply states that any amendment done through Article 368, then it can't be challenged under Article 13. If amendment is against to the fundamental rights, then also it cannot be challenged under Article 13. Case Keshwanand Madhava Menon versus State of Bombay, AIR 1951 SC 128. Before going to this case, let us know about the meaning of the prospective and retrospective. Prospective means it doesn't consider about the past, it will consider only about the present things. Retrospective means it will consider past, present, and future. Now let us know about the issue about this case. The petitioner was prosecuted in 1949 under the Indian Express Act 1931. During the pendency of the criminal proceeding, the Constitution of India came into force and the petitioner challenged the validity of the Act on the ground that it was inconsistent with the fundamental rights under Article 19(1) Clause A, and pledged that the proceeding commenced against him before the commencement of the Constitution could not be continued after the commencement of the Constitution. Judgment. The Supreme Court held that Article 13 Clause 1 has no retrospective effect and it is only prospective in its operation. Doctrine of severability. Severability means separation. The doctrine of severability means that when some particular provision of a status offended or is against a constitutional limitation, but the provision is severable from the rest of the statutes, only that offending provision will be declared void by the court and not the entire statute. In simple terms, let us know when only one section is inconsistent, only that will be removed, remaining act will be enforceable. When only one section is correlated or dependent will be removed, that also, and remaining act will be usable. Now let us know the case law. A.K. Gopalan vs. State of Madras. In this case, Section 14 of the Prevention Detection Act 1950 was challenged by A.K. Gopalan on the ground that the detention was unlawful and thus violated his fundamental rights under Article 21, right to personal liberty. But in this act, Section 14 provided that no rights to be detained to disclose the grounds in the court. So, applying the doctrine of severability, Supreme Court held that only Section 14 of Preventive Detention Act 1950 was violated the fundamental rights. Hence, Section 14 was severed from the Act. Rest of the Act remained in force. Next is doctrine of eclipse. Any law which is inconsistent with fundamental rights is not invalid. It is not dead but become inoperative. The inconsistency can be removed by constitutional amendment. In simple words, till the time the law violates fundamental rights, it will be overshadowed and due to any amendment. If the violation ends, then the law will become operative again. Now let us know the case law of eclipse. Bikharji vs. State of MP. Issue. The MP government passed an act in the year 1950 for nationalizing the motor transport before the commencement of the constitution. The status was challenged by the petitioner under the Article 19(1)(g). The Central Government Amendment Act in 1955 on 27/4/1955 enabling the state to nationalize motor transport. Judgment. The Supreme Court held that the status of the MP state nationalizing the motor transport 1950 was cured by the 4th Amendment Act 1955 and therefore the doctrine of eclipse has been applied and such act is valid. Next one is doctrine of waiver. The doctrine of waiver of the right is based on the premises that a person is in his best judge and that he has the liability to waive the enjoyment of such rights or conferred on him by the state. However, the person must have the knowledge of his rights and that the waiver should be voluntarily. One can voluntarily waive legal rights, however, one cannot waive off his fundamental rights. Fundamental rights is based on a public policy, thus, individuals are not allowed to waive off his such fundamental rights. Also, it is the constitutional mandate of the courts to see that the fundamental rights are enforced and guaranteed, even if one might waive of them. Now let us know the case. Bishar Nath versus Income Tax Commissioner. The petitioner whose matter had been referred to the Investigation Commissioner under Section 5 Clause 1 of the Taxation of Income Act 1947 was found to have a settlement under the Section 8A to pay rupees 3 lakhs in the monthly installment by the way of areas of tax and penalty. In the meanwhile, the Supreme Court is another case held that the Section 5 Clause 1 is ultra vires the Constitution as it was inconsistent with Article 14. So, the appellant cannot waive his fundamental rights. Thank you. Please like and subscribe. Next video will be on Article 14.